A lot of people ask me, how do you beat a DUI charge in Ontario? I was driving and I was drunk and the police caught me. How can I possibly be proven not guilty? Well, it comes down to evidence. My name is Finlay. I'm a criminal defense lawyer with Strategic Criminal Defense in Toronto. First, DUI comprises 3 charges: having a blood alcohol content over the legal limit while driving, impaired driving, and refusing to provide a breath sample. In Canada, we call these charges impaired driving charges. To prove that you're impaired, the Crown Attorney has to lead evidence that suggests that your ability to operate a motor vehicle was impaired by alcohol. Commonly, that's witness testimony from witnesses like the police or civilians that indicate that there's indicia of impairment, like swaying, a smell of alcohol, slurring of speech. To prove that your blood alcohol content is over the legal limit is a little different. Commonly, what the police do is take your breath samples that show how high your blood alcohol content is. By taking your breath samples, the police search you without a warrant. The burden is then on the Crown Attorney to prove that that search was reasonable and complied with the Charter of Rights and Freedoms. To prove a search is reasonable and therefore compliant with the Charter of Rights and Freedoms, the Crown Attorney must prove that the search was conducted reasonably, that it complied with law, including the criminal code, and that the law itself is reasonable. For example, if the police collected your breath sample at the roadside with an approved screening device, which is a handheld device, the Crown Attorney has to prove that that sample was taken forthwith, which means without delay. If the police form grounds to believe that you're drunk driving, they can arrest you and then bring you back to the police station for evidentiary samples. However, before they collect those evidentiary samples, they have to give you the opportunity to speak to a lawyer. These are the samples a judge relies on to determine if you're guilty. Legally, you're allowed to speak to any lawyer you wish. That's commonly not applied in practice. What happens is the police ask if you know a lawyer, and if you can't name one off the top of your head, they offer to allow you to speak to duty counsel, which is a legal aid lawyer funded by the province. We carefully examine all the evidence and determine if there's an indication that you expressed a desire to speak to a different lawyer other than duty counsel. If there was, potentially, we can argue that the police funneled you or inappropriately steered you to duty counsel when you may have chosen to speak to a lawyer of your own choice. That can be used to exclude the evidence of the breath samples and have you be found not guilty. If you've been charged with drunk driving in Ontario, it's important for you to retain a lawyer with trial experience to challenge the evidence against you in court.